In this video, you are going to learn some important information about your case. You have been charged with a felony. A felony, by definition, is a case that carries a potential sentence in the Department of Corrections. Now, a felony begins one of two ways. A complaint can be filed or an indictment is filed. Most likely, a complaint has been filed in your case. Whether a complaint has been filed or whether an indictment has been filed has little to do with the outcome of the case. One is not worse than the other. It's just a different procedure. Most likely, there's a complaint in your case. Now, I file an entry of appearance and tell the prosecutor and the court that I represent you. I also file a motion for disclosure. That motion for disclosure requires the state to give us any evidence they have against you. They have to give us police reports, statements of witnesses, things like that. When I get those, I review those to see if there's any inconsistencies, to see if there's any outright lies, to see whether or not your rights have been violated. And I'm going to send a copy to you for you to review. I want you to review it thoroughly. If you need to get with me and discuss the police report, let's do that. While this is going on, there are going to be a number of court appearances. You don't have to be there. I will be there on your behalf. The only time that you have to be in court is when I tell you there's a court date and you have to be there. During the course of this case, while we're waiting for a preliminary hearing, I may be negotiating with the prosecuting attorney. They may make an offer for a plea bargain. I can't accept that offer without your authority, and I'll discuss it with you. Anytime I get an offer, I will forward that to you. But you're the person that makes the final decision as to whether or not you want to accept any offer. Now, if we can't arrive at a plea bargain, we're going to go to a preliminary hearing. A preliminary hearing is where the state has to show probable cause to believe that a crime was committed and probable cause to believe that you were involved in that crime. Now, probable cause is the lowest level of legal proof that there is. It simply requires somebody to come in and say that they had property stolen and there's some reason to believe that you did it, or that a fire was started and they have reason to believe that you did it, or that drugs were sold and they have reason to believe that you did it. It's the very lowest level of legal proof. If the state can convince the judge that there's probable cause that you committed the crime, it's not a determination of guilt or innocence. You can't win at a preliminary hearing. A judge cannot find you not guilty. So we don't put on any evidence at all. It is a good opportunity to learn what the state's evidence is. But if the judge finds there's probable cause, he binds your case over to the circuit court. Now, another way to get your case to the circuit court is through an indictment. If you're indicted, there is no preliminary hearing, or you can waive your preliminary hearing. Why would you waive your preliminary hearing? Well, you'd waive your preliminary hearing in a circumstance where you've reached a plea bargain already and we're just going to the circuit court because that's where the case is finally disposed of. In the circuit court is where you are arraigned, whether or not you've been bound over after a preliminary hearing or whether or not you've been indicted. And an arraignment is where you enter a formal plea of not guilty. All felony cases start with a plea of not guilty in the circuit court. After we have entered our plea of not guilty, we either set the case for a guilty plea and sentencing, if we worked out a plea bargain, or the court will give us a schedule. In that schedule, he will tell us, or she will tell us when to file motions, whether or not we're going to have a hearing, what date we would have a hearing on those motions, and we have to be present if we're going to have a hearing on those motions. The court would set a date for a pretrial, and the court would set a trial date. That trial date may or not be an actual trial date. It may have to be continued. During the course of the case in the circuit court, we may want to do more discovery, and that would be depositions. Depositions are where we take a witness and bring them to an office with a court reporter and put them under oath and ask them questions about what they know about the case and what their testimony is going to be at trial. That's a very useful tool if we're going to go to trial, or even in discovery to show the state how weak their case is. The court reporter charges us to show up at the deposition and to transcribe the testimony, and then to turn that into a booklet called a deposition. That money goes to the court reporter. It doesn't go to me, but the court reporter will not give us the depositions until we pay for the depositions. So if we're going to take depositions, I'm going to discuss that with you beforehand to make sure that you authorize that payment. After we have completed all the discovery, we either strike a bargain, a plea bargain, or we go to trial. If we're going to go to trial, we have a pretrial where we discuss certain issues with the judge, and then we have a trial. If we have a plea bargain, the judge will set it for a date for a guilty plea and for sentencing, and the prosecutor will have made a recommendation. Will the judge follow the recommendation? Well, if the judge doesn't follow the recommendation, the judge will have to tell us, and you can withdraw your guilty plea. In the years that I've been practicing law, I've had that happen 1 or 2 times at best. Generally, the judge follows the recommendation. Now, if you go to trial, there are certain things that you need to know. At a trial, the state puts on its evidence. We have a right to put on evidence if we have evidence. You don't have to testify if you don't want to testify. If you want to call witnesses, we can subpoena witnesses to come testify on our behalf. At the end of the trial, the jury is either going to find you guilty or not guilty. If the jury finds you guilty, either the jury or the judge will issue a sentence in your case. You have a choice as to whether or not you want the jury to sentence you or the judge to sentence you. We can discuss that if we get that far. That pretty well covers the procedure for handling a felony case and what I'm going to do for you. I'm going to be making a lot of court appearances on your behalf that you don't need to attend, but you can attend if you want to. You have a right to be present at any proceeding, even if I'm just going to go in and say, Judge, continue this case for a month. We're still waiting for discovery, or we have some other reason to continue it. I hope this has answered your questions. If you have any other questions, of course, please feel free to call me. Thank you.